Hello, everyone, and welcome. My name is Shatanda, and I'll be your trainer for this session. Over the next few minutes, my one and only goal is to get you fully prepared to walk into the testing center and pass your property and casualty exam on the very first attempt. We're going to cover a lot of ground, but we'll do it logically and methodically. As we go along, please feel free to drop your questions below in the chat, and I will do my best to answer them at the end. Let's get started. So let's start with the absolute core concept. What is insurance? Insurance is a transfer of risk. Think of it like this: 100 neighbors all live in identical houses. Each knows there's a small chance their house could have a fire this year, which would cost $200,000 to rebuild. Instead of each person saving that full amount, they each contribute $2,000 to a shared pool. If one house burns down, the $200,000 from the pool is used to rebuild it. Everyone traded the risk of a huge uncertain loss for a small certain cost. That's insurance in a nutshell. For the exam, you will need to know the difference between pure risk and speculative risk. Pure risk is the only kind that's insurable. It involves only the chance of loss or no loss, no chance for gain. A fire is a pure risk. Speculative risk, like gambling or buying stocks, involves a chance to win or lose. It is not insurable. Next, let's nail down perils and hazards. A peril is the cause of the loss. Fire, wind, theft, those are perils. A hazard is a condition that increases the likelihood of a peril occurring. There are three types you must know, and you need to be able to identify examples. Physical hazard, something you can see or touch. Examples: oily rags in a garage, a tree branch hanging over a roof, bald tires on a car, faulty wiring in a wall, a cracked sidewalk. Moral hazard: this is about dishonesty or bad character. It's an intentional increase in risk. Example: an applicant who has previously committed insurance fraud, or someone who lies on an application to get a lower premium. Morale hazard: this is about carelessness or indifference to loss because insurance exists. It's an unintentional increase in risk. Example: why should I lock my car? It's insured. Or leaving a candle burning unattended. So, a physical hazard, faulty wiring, can increase the chance of a peril, fire, leading to a loss. Not every risk can be insured. For a risk to be insurable, it must meet certain criteria. A good way to remember them is the acronym DCAN-HAM. Definite: the loss must be definable in time, place, and cause. Calculable: the value of the loss must be measurable. Affordable: the premium must be affordable for the average person. Non-catastrophic: the loss shouldn't be so massive that it could bankrupt the insurer. This is why war and nuclear events are excluded. Homogeneous: there must be a large group of similar risks. Accidental: the loss must be unforeseen and unintended. Measurable: the frequency and severity of losses should be statistically predictable. How can an insurance company afford this? The law of large numbers. This principle states that the larger the number of similar exposure units, e.g., houses, cars, the more predictable the number of future losses becomes. Insurers use this to calculate premiums. The opposite of this is adverse selection. This is the tendency for people with a higher than average chance of loss to seek out insurance more than others. For example, someone who learns they live on a fault line might rush to buy earthquake insurance. Underwriters are the gatekeepers who work to prevent adverse selection by evaluating risks. Elements of a legal contract. An insurance policy is a legally binding contract. It needs four essential elements: agreement, a definite offer by one party, and an acceptance by the other. In insurance, the applicant makes the offer by submitting the application, and the insurer accepts by issuing the policy. Consideration, the value exchanged. The applicant's consideration is the premium paid and the statements on the application. The insurer's consideration is the promise to pay for covered claims. Competent parties. Both parties must be of legal age, mentally sound, and not under the influence. Legal purpose. The contract must be for a lawful reason and not against public policy. Insurance contracts are unique. They are contracts of adhesion, written by the insurer, The insured adheres to it. If there's an ambiguity in the wording, a court will rule in favor of the insured. Aleatory, an exchange of unequal values. You might pay $2,200 in auto premiums, and the insurer pays out a $30,000 claim after an accident. Personal, between the insured and the insurer. You can't just assign your auto policy to the person who buys your car. Unilateral. Only one party, the insurer, makes a legally enforceable promise. You can stop paying your premium anytime, but the insurer must pay valid claims. Conditional. Certain conditions must be met for the contract to be executed. You must pay the premium and report losses promptly. You'll see questions on these on your exam. Insurable interest. You must have a financial stake in the insured item. For property insurance, this must exist at the time of the loss. Indemnity, to restore to the financial position enjoyed before the loss, no better, no worse. Utmost good faith. Both parties must be completely honest and disclose all relevant facts. Representations versus warranties. A representation is a statement believed to be true to the best of one's knowledge. A warranty is a statement guaranteed to be true. All statements on an insurance application are considered representations. A false representation is a misrepresentation. If it's material, meaning the insurer would not have issued the policy had they known the truth, it can void the policy. Concealment is intentionally withholding a material fact. Underwriting is the process of selecting, classifying, and rating risks. Underwriters use several sources: the application, consumer reports, inspection reports, and for auto insurance, motor vehicle reports, MVRs. The Fair Credit Reporting Act, FCRA, is a federal law that protects consumers. If an insurer takes adverse action based on a credit report, they must inform the consumer of the credit reporting agency's name and address. Insurers use different methods to determine premiums. Rating methods include judgment, manual, and merit. Judgment relies on underwriter experience. Manual rating, the most common, classifies risks into categories. Merit rating adjusts premiums based on individual loss history, rewarding low risk behavior. Understanding these methods is crucial for accurate policy pricing and risk assessment. Now let's talk property insurance. Remember the acronym DICE for policy structure, declarations, insuring agreement, conditions, and exclusions. When a loss occurs, how do we value it? Actual cash value, ACV, replacement cost minus depreciation, replacement cost, today's cost to replace with new materials of like kind and quality, agreed value, a value agreed upon by both parties in advance, often used for fine art. The coinsurance clause encourages insuring property to its full value. For homeowners, the standard is 80%. Let's see how the penalty works. Imagine you have a house with a replacement cost of $200,000. The 80% coinsurance requirement means you should insure it for at least $160,000. You insure it for $100,000, what you did insure. You have a partial loss of $40,000. The formula is insurance carried, insurance required. X loss, payout $100,000, $160,000, X $40,000, or $25,000. You're out $15,000 because you were underinsured. Vacancy versus unoccupancy. Unoccupancy means the premises are empty but contents remain, e.g., you're on vacation. Vacancy means the premises are empty of both people and contents. Coverage is often restricted after 60 days of vacancy. Deductibles. The portion of the loss the insured pays. Higher deductibles lead to lower premiums. Limits of liability. The maximum amount the insurer will pay for a loss. Dwelling policies are for properties where the owner may not live, like rentals. DP1 Basic covers fire, lightning, internal explosion. ACV loss settlement. The extended coverage EC perils can be added. Remember the mnemonic WC Shaver. Windstorm, civil commotion, smoke, hail, aircraft, vehicles, volcanic eruption, explosion, riot. DP2 Broad adds many more named perils. Remember BB Bice Golf, bursting of heating systems, burglary damage, breaking of water heaters, ice, snow, sleet weight, collapse, electrical damage, glass breakage, objects falling, leaking of water, steam, freezing of plumbing. It also upgrades coverage on the dwelling to replacement cost. DP3, special, the best form, covers the dwelling for all risks or open perils, meaning everything is covered unless specifically excluded. Homeowners policies are package policies for owner occupants. They bundle property Section 1 and liability Section 2 coverage. HO3 special form, the most common. Open perils on the dwelling, coverage A and B. Named perils on personal property, coverage C. HO4 contents broad form for renters, covers personal property. HO5 comprehensive form, the best coverage, open perils on both the dwelling and personal property. HO6 unit owners form for condo owners. Now let's break down the coverages. Coverage A, dwelling, the house itself. Coverage B, other structures, detached garages, sheds, fences, typically 10% of coverage A. Coverage C, personal property, your stuff, typically 50% of coverage A. Coverage D, loss of use, pays for additional living expenses if your home is uninhabitable after a covered loss. Typically 30% of coverage A. Coverage E, personal liability, protects you if a claim is made or a suit is brought against you for bodily injury or property damage. Coverage F, medical payments to others, pays necessary medical expenses for others who are accidentally injured on your property, regardless of fault. For businesses, the commercial property policy is key. It's composed of several parts, including the causes of loss form, causes of loss forms, basic, broad, same perils as the DP forms, and special, open peril. Business income coverage covers the loss of income a business suffers after a direct physical loss. Extra expense coverage covers the extra costs to keep a business running after a loss. A critical point, flood damage is excluded from all standard dwelling, homeowners, and commercial property policies. Flood insurance is a separate policy obtained through the National Flood Insurance Program, NFIP. Welcome to our final segment. Casualty or liability. Insurance protects you when you're legally liable for injuring others or damaging their property. Liability is based on the legal concept of negligence. For negligence to exist, four elements must be proven: legal duty, a duty to act reasonably, breach, failure to perform that duty, proximate cause, the breach directly led to the injury, damage, damages, an actual injury or loss occurred. Defenses against negligence and other liabilities. Defenses, common defenses include assumption of risk, the injured party knew the risk involved, and comparative negligence. Missouri is a pure comparative negligence state. This means the injured party can recover damages even if they are 99% at fault, but their reward will be reduced by their percentage of fault. Other liabilities. Strict liability applies to inherently dangerous products or activities. Vicarious liability is when one person is held liable for the actions of another, like an employer being liable for an employee's on the job negligence. Let's break down the PAP. Part A, liability, pays for bodily injury, BI, and property damage, PD, you cause to others. Also includes supplementary payments for things like bail bonds and loss of earnings while attending court at the insurer's request. Part B, medical payments, pays medical expenses for you and your passengers regardless of fault. Part C, uninsured or underinsured motorist, UM/UIM, protects you from drivers with no or not enough insurance. Part D, damage to your auto, physical damage coverage for your car. This has two parts: collision, hitting another car or object, and other than collision, comprehensive. Theft, hail, hitting a deer. Each has its own deductible. The Missouri Department of Commerce and Insurance. This part is critical. The head of the department is the director. The director enforces insurance laws. They do not write them. They issue licenses, conduct exams of insurers, and can issue cease and desist orders. These duties ensure a fair and transparent insurance market, safeguarding consumer interests and maintaining industry standards. To get your license, be 18, pass the exam, and apply. To keep it, 16 hours of continuing education every 2 years, with 3 of those hours in ethics. You must report any change of address to the director within 30 days. You must also report any administrative actions or criminal convictions within 30 days. You also have a fiduciary duty to your clients and insurers. Unfair trade practices. These are illegal and will be on your test. Misrepresentation, lying about a policy, rebating, offering a potential client anything of value not specified in the policy to induce a sale. This is illegal. Twisting, using misrepresentation to convince a client to switch policies to their detriment. Defamation, making false statements about another insurer or producer. Unfair claim settlement practices, failing to promptly acknowledge communications regarding claims, or refusing to pay claims without conducting a reasonable investigation. Must know Missouri regulations. Memorize these numbers. Mandatory auto liability limits 25, 50, 25. $25,000 for bodily injury to one person, $50,000 for bodily injury per accident, $25,000 for property damage per accident. Auto policy cancellation. Insurers must give 10 days notice for cancellation due to non-payment and 30 days notice for other reasons or for non-renewal. Missouri Fair Plan, property insurance of last resort. It provides basic coverage on an ACV basis. Maximum limit is $200,000 for residential and $1,000 for commercial. It does not cover liability. Workers' compensation, required for employers with 5 or more employees. But for employers in the construction industry, it's required for 1 or more employees. Okay, we've made it to the end of this training segment. On exam day, read each question carefully. Eliminate obviously wrong answers to narrow choices. If unsure, make an educated guess. Staying calm is crucial to maintain focus and clarity. These strategies enhance your ability to perform effectively under pressure. Feel free to ask any questions you might have. Thank you for your attention and good luck with your endeavors.